まずは D クエストの説明をさせていただきます。D クエストはですね、企業リスクコンサルティング事業をやっておりまして、内部通報ヘルプラインサービス、不正調査サービス、各種セミナー支援のプログラムをやっております。で、コンセプトとしましては、データ、ディフェンス、デベロップメント、この3つの D を活用した事業展開をしております。で、健全で持続可能な企業活動を支援するということをモットーにしております。2000年の4月ですね、私たち D クエストグループは、21世紀の社会に備えてですね、人と組織のためのリスクマネジメントを事業の中核に添えた新たな組織を立ち上げました。21世紀の企業に求められる最も重要なもの、その筆頭がコンプライアンス経営であり、それを支える健全性、持続可能性のマネジメントであると考えられるからです。D クエストグループは国際社会において、ますます重要となるヒューマンリスクマネジメントに特化したコンサルティングファームとして、企業価値に貢献する質の高い情報、システム、教育、ノウハウを提供し支援いたします。今回のシンポジウムの中でですね、EU 全体における内部通報関連の法律として GDPR が施行されましたが、一部の国では GDPR 以外にもそれぞれ独自に法律の制定を行う国があります。その中でフランスが独自ルールを制定して GDPR を強化した方向に向かっており、その内容がフランス語で書かれているということで、分かりにくいことということから、今回 D クエストでですね、海外シンポジウム第2弾として本テーマを取り上げさせていただきました。弊社としても海外進出企業様が当局への本規則への対応の遅れとかですね、またですね、報告事項の失念によって罰則対象になっているということを、たまにお聞きします。その中でですね、本テーマは見逃せない重要な問題と考えております。ウェビナーを通してシンポジウムということもあり、聞きづらい面やですね、同時通訳ができないということでご不便をおかけすると思います。本講座は英語による講義となりますけれども、後日ですね、日本語というものでも配信を計画しております。また、事前にいただいているご質問に関して講義中解説をいただきますが、講義終了後であってもですね、弊社担当者宛てにいただければ可能な範囲で回答させていただきたいと思います。本日のセミナープログラムです。大まかなところとしましては、この後、レクチャーをしていただきます全般的なサパン通報がですね、フランス法に対する影響についてという内容とですね、内部通報の GDPR、フランスの現状、こちらはですね、細かく分かれておりまして、フランスの労使関係の動向であるとか、労働法の内部通報者保護であるとか、海外企業のサパン通報がもたらす困難と懸念である。そしてですね、内部通報実施に関するフランスのデータ保護法 CNIL ですね、ガイドラインについての説明をしていただきます。そしてですね、その後に質疑応答、簡単な質疑応答をさせていただいて、最後に弊社からのご案内をさせていただきます。それではパネリストの紹介です。パトリック・ティエベート。彼はですね、労働法と雇用法を主に対応しています。すべての労働、雇用および人事問題について、フランスおよび国際的な活動に助言しております。活動する企業に助言しています。で、彼は日常的に労働力削減計画、または企業再編の準備と実施、および上場企業、または非上場企業の買収やですね、移動、または合併におけるすべての労働問題の処理においてクライアントを支援しています。で、次にエレーヌ・ルボンさん。彼女はですね、データ保護法のチームの責任者です。主な業務としましては、データ保護と規則遵守に重点を置いており、監査の実施であるとかですね、戦略の開発と GDPR の修復計画の作成、データ保護当局への対応など、個人データとプライバシーに関するあらゆる問題についてクライアントを支援しています。で、続きまして、ミシェル・サパン。彼はですね、上級顧問の弁護士です。政府及び公共部門法のハイステークス、国内及び国境を越えた問題であるとかですね、 特にアフリカ大陸に関する問題について助言をしています。腐敗防止法に関する彼の豊富な専門知識はですね、コンプライアンス問題における中核的な強みを持っているというふうに考えて、非常に貴重な存在です。で、過去においてはですね、フランスのオランド大統領の下で、労働雇用大臣であるとかですね、財務大臣を歴任してきた経緯がございます。それではですね、パネリストの方の説明をそれぞれしていただきたいと思います。で、切り替えに少々時間かかりますのでお待ちください。
Good morning to all of you. I'm very pleased and honored to speak today alongside Patrick and Hélène about the Sapin II law, its provisions concerning whistleblower and the obligation imposed on companies working in France and in Europe to project them. Please excuse my poor English. My knowledge of the language, unfortunately, doesn't allow much communication on my part. Please allow me to apologize as well to this particular situation. In fact, the very author of the law, myself, Michel Sapin, commenting on a text that jurists and companies in France and in the world call the Sapin II law, is rather unusual. This implies a certain duplication of personality, as you may imagine. I sincerely hope you will forgive this seemingly lack of modesty. I did not choose the name myself, but it appears to have become the norm. This law resulted from a first text adopted in 1993 during my first time as Minister for Economic Affairs and Finance. It was proposed to fight against some corruption instances in France and on French soil. The Sapin II law, from later adopted in December 2016, focus on preventing corruption and combating global corruption, especially in the case of French companies trying to win markets in a questionable way. In the broader term of OECD's International Convention preventing corruption has since become a priority in France. Here are the main tools used to prevent corruption. First, implementing a compulsory corruption prevention plan in large companies. The latter must assess risk, describe procedures, define necessary training, and so on. These plans are mandatory since mid-2017. Secondly, another tool can be found in the French Anti-Corruption Agency, in charge of verifying the prevention plan's implementation and quality. This agency has significant resources and important sanctioning power. It has been carrying on in-depth inspection for the past 2 years. Finally, the third tool lies in the establishment of whistleblower protection in the fight against corruption, as well as, more generally speaking, in all areas where the law is violated, or even further, in the event of threats that could cause serious harm to the general interest. The statute compels concerned companies to set domestic or external procedures in order to guarantee the anonymity of a person concerned and his or her safety. Patrick and Hélène will tell you more about this later on. The Sapin II law has put France on the map for being the country with the highest standards on corruption prevention and whistleblowers protection. With European directives being progressively taken, it should become possible to standardize procedures, thus simplifying the work of companies operating in the EU. Finally, I want to stress the importance at an international level of a progressive harmonization between countries. Of course, we still have a long way to go. I wish you all a good webinar and remain at your disposal alongside the Franklin Lawyers, especially Patrick and Helen, to address these issues more precisely today or in the upcoming months if you feel the need. Thank you all very much for your attention.
Hi, thank you, Michel. So we will start with the first part of the presentation. And this first part is regarding whistleblowing schemes and GDPR. So to tell you a couple of words regarding the background, the first complaints in France took place in 2005. It was a complaint issued by trade unions against the McDonald's whistleblowing scheme and another branch of an American group in France. So after these complaints, some discussion took place between the French Data Protection Authority at the CNIL, the American Security Exchange Commission, the SEC, and the American Embassy in Paris. Following these discussions, the French Data Protection Authority, the CNIL, issued some guidelines in order to help French company or French branch of foreign companies to implement data protection whistleblowing schemes, in compliance with data protection laws in France. So the first guidelines has been issued in 2007 and has been amended several times. And the last version of these guidelines has been adopted on July last year, but published in December last year, so 6 months ago. And I have to say that thanks to Sapin 2, the scope of the guidelines issued by the CNIL are very clear. So please note that, of course, these whistleblowing schemes allow companies to gather, to collect and process personal information regarding quite a lot of people, but especially regarding employees. And please note that in GDPR, we have an article, which is the article 88, which says that member states, so in our case, France, can issue specific rules regarding processing of employees' data. So this means that in France, if we want to assess the compliance with data protection rules on a whistleblowing scheme and more generally on processing of employees' data, we have to assess the data processing in compliance with the French law and especially in French labor code. So you won't find very precise rules regarding employees' data and processing of employees' data within the GDPR. You have in France and in other EU country member states, you have to look at the national law. And so maybe, Patrick, we can go to the French national law.
Thank you very much, Hélène. First of all, let me tell you how happy I am with my partners to participate to this DQuest webinar. We're very happy about that. Yeah, what I'd like to say, I'd like to go back to the past a little bit, because I can assure you that implementing a whistleblowing scheme was not an easy process, and I think that both Hélène and Michel will share my point of view. At the very beginning, the French data protection watchdog, the so-called CNIL, was very suspicious about these actually whistleblowing schemes. Let's go back to the past a little bit. When the American Sarbanes-Oxley Act was passed, you may recall that entities doing business in the US, including, of course, foreign companies having set up their operation in the US, were required by the Sarbanes-Oxley Act to implement procedures for the confidential anonymous submission by employees of concerns regarding accounting and auditing controls. And we started by this because French companies, presumably like Japanese companies, doing business in the US had to comply with the Sarbanes-Oxley Act. And I remember that one of the very first cases we had in France was in 2005 regarding McDonald's. McDonald's, unsurprisingly, had a whistleblowing scheme complying with the Sarbanes-Oxley Act. And when this scheme was submitted to the CNIL, so the French Commission, the CNIL said that whistleblowing schemes should not be transformed into, quote, an organized system of professional denouncement. So at the very beginning, this was regarded as a way just to denounce people. In my view, there are two, I would say, points behind this initial position of the CNIL. First of all, obviously in France, this kind of system could echo to some dark side of our history, and especially during the Second World War, with denunciation of people to the Nazi regime. And do not underestimate the cultural things, because if you look at Germany, Germany does not have any whistleblowing legislation at this point in time, whereas Germany is known to be all the time at the forefront of the laws. I mean, when there is a new EU directive, Germany is one of the very first countries implementing directive. They don't have anything so far. So this was the first reason, cultural reason. Mistrust regarding these whistleblowing schemes. The second reason is we do have in France unions, we do have in France employee representatives, and the CNIL says, hey, do we really need whistleblowing schemes, whereas the works councils, whereas the staff delegates are allowed, they have the prerogatives to denounce any issues in the workplace. So you see these things. I remember that also in 2005, the CNIL decided to timidly encourage whistleblowing policies, provided that they were strictly limited to financial accounting, banking and anti-bribery areas. And in 2009, the French company Dassault Systèmes that had implemented a whistleblowing scheme. Dassault Systèmes was considered by the French CNIL as having implemented an invalid whistleblowing scheme. Why? Because the Dassault Systèmes whistleblowing scheme exceeded the financial, accounting, banking, and anti-bribery areas. The Dassault Systèmes gave the possibility to whistleblowers to report alleged violation regarding discrimination, regarding harassment, regarding conflict of interest. And then the CNIL said, I'm sorry, Dassault, you went too far. So you can see that the beginning was difficult. In 2007, we had our first law regarding ethical alert in 2007, aimed at protecting employees reporting corruption facts. This was the very first legislation in France. And so, people who testified in good faith, who reported in good faith to their employer or to the French judicial or administrative authorities, corruption facts that they have been informed of, were protected under the law. 2007. 2011, 2013, the French lawmaker passed several whistleblowing legislation. However, at that time, the legislation that were passed, and if I don't make a mistake, we had one in financial sector, one in major economic crime, another one regarding public health and environment, and last but not least, prevention of conflict of interest. So, from 2011 to 2013, we passed in France 5 legislation about whistleblowing. However, again, at that time, we only had sectorial whistleblowing protection. Where we had a significant improvement is in 2016 with the Sapin 2, Sapin 2 Act, which implemented for the first time general tools. So we were no longer in this very sectorial whistleblowing legislation. We had a general one applicable to all sectors of activity and giving for the first time a clear definition of who can be a whistleblower. So I think that, and it's not because Michel is with us today that I say this, but the Sapin 2 legislation indeed was a significant improvement of the whistleblowing legislation. If I may continue, because I just wanted to give you some, I would say, background about the history, I would like, before we go further, I would like to give you some information about French employment law. I'm sorry, I did not introduce myself. My name is Patrick Thiebard, and I am at Franklin one of the two employment law partners. And you know, we have different ways for an employee to blow the whistle. For instance, in my country, in France, an employee has the right to blow the whistle when the employee considers that he worked in an unsafe environment in the workplace. We do have in the French Labor Code several articles, several provisions explaining that an employee may alert the employer of any work situation that he believes may present a serious and imminent danger to his life or to his health, as well as any defect that may find in the protection system. So I think it's important to say that. And so the employee has the possibility to stop working when he comes to the conclusion that his life or his health is in danger. Unsurprisingly, with the COVID-19, we saw several employees who said, my employer didn't take the necessary steps to protect my health due to COVID-19 pandemic, so I have the right to withdraw. I have the right to stop working. But of course, the employee must have reasonable grounds to believe that his workplace presents a serious and imminent danger. This danger will be appreciated by the judge, and only the judge, from an employee's point of view. In short, depending on the employee's knowledge, depending on the employee's experience, the judge will be in a position to evaluate whether the employee had good and valid reason to consider that his life or health was in danger. And again, ladies and gentlemen, if the employee had the right to withdraw, then no sanction, no salary deduction can be taken against the employee. The employee cannot be dismissed. The dismissal would necessarily be null and void. So I think it's important to have this in mind. I also told you when I started my presentation that the CNIL was reluctant at the very beginning to support whistleblowing schemes because we have in France employee representatives. In France, employee representatives have very significant prerogatives. And you should not, for those of you who have operations in France, you should not underestimate their prerogatives. Staff representatives have the right to submit individual and collective complaints from employees regarding wages, if you prefer remuneration, but also, and more generally, regarding any breach to the labor code. Let me give you an example. Under French law, employees can work under fixed-term contracts, but it is highly regulated. If the employer breached the law regarding fixed-term contracts, then the Works Council, what we call now the CSE, the Social and Economic Committee, this is the new name for the Works Council, can blow the whistle. More generally, ladies and gentlemen, staff representatives ensure the collective expression of employees. So it is very important to have this in mind. And in the field of health and safety and work conditions, as mentioned, you can see now in the screen, yes, the CSC members have the possibility to investigate, to carry out analysis on the risk workers may be exposed. Keep in mind that employees' reps may also take initiatives and take actions in order to prevent moral harassment, sexual harassment, and sexist behavior. So, as you can see, the French employees reps have a right to alert. They have, in the event of an infringement of the employees' rights, they have this possibility. So please keep this in mind, because there is no inconsistency between the Sapin II Act and the prerogatives of the French employees reps. And I don't think that in France, the employees reps and the unions more generally are against Sapin II, not at all. The CNIL thought that it could be an interference. Sapin II could be, or more generally, any whistleblowing legislation could be an interference in the prerogatives of the employees' representative, that at the end of the day, this is not true. So the two systems, the Works Council alert right on the one hand, and the Sapin II Act on the other hand, can work together and can coexist without any particular problem. So this is the role of staff representatives. And now, obviously, there are some interactions between Sapin II and their prerogatives. We will see a little bit later that in France, when you implement a whistleblowing scheme, you can do it through a company agreement to be signed either with the unions or to be signed with the Works Council. And just to give you this information, the company-wide agreement to be signed is important, because when there is an alert, then obviously the alert must be reported to someone. Who should be the recipient? The CSE, i.e. the Works Council, cannot be the recipient. So you will have to determine in the policy that will be part of the company-wide agreement signed with the union or the Works Council, who will be the person who can receive the alerts and under which conditions. Indeed, in France, entities with more than 50 employees are required to have a whistle-blowing policy. It does not mean that when you are below 50, you cannot. You can do it on a unilateral basis and on a voluntary basis, but I would even encourage you, if you have less than 50 people, to have a whistleblowing policy. But for companies with more than 50, it is a requirement. So please make sure that in your company in France, you have it, if you have at least 50 employees. As I said, you can go through a company-wide agreement or a unilateral basis. Let me start by the company-wide agreement. President Macron, when he was elected, said that French employment law should be more flexible. And in order to do this, he decided to give to all companies in France the possibility to sign agreements. For those of you who have unions. You may sign agreements with unions. So, going back to the whistleblowing, you can sign a company agreement with your unions in France dealing with the whistleblowing policies. And then you will sign it, as mentioned on the PowerPoint presentation, with union delegates representing more than 50% of the workforce, or, failing that, with union delegates representing more than 30% of the workforce, subject to referendum approved by a majority of the employees. If you do not have any unions, you can sign agreements with employee representative, what we call the Works Council, and now the CSE. You have one as soon as you reach a level of 10 employees. So unsurprisingly, when you are at the level of 50 employees, you have a Works Council. So, ladies and gentlemen, it's not because you don't have any unions that you cannot sign an agreement. So, make sure that you do it. What happens if you cannot sign an agreement with the unions? If you cannot sign an agreement with the Works Council because, for some reasons, you have disagreement, it is possible. In this case, French law gives you the possibility to go through the unilateral document. So this is a policy which will have been prepared by the employer only and under the employer's responsibility. Obviously, ladies and gentlemen, as a practitioner, my recommendation is always to negotiate with unions, to negotiate with the Works Council. And you go through the unilateral basis only if, for some reasons, the negotiations failed. But please start through the negotiation. Don't start through the unilateral basis. And now, if we can go to the other slide, I'd like to say who is regarded as a whistleblower. So now, we go through the Sapin 2 legislation. Let me give you the definition of a whistleblower according to the legislation, the French legislation. A whistleblower is an individual who reveals or reports selflessly and in good faith a crime or a misdemeanor, a serious and manifest violation of an international commitment duly ratified or approved by France, a unilateral act of an international organization taken on the basis of such an undertaking, law or regulation, or a serious threat or harm to the public interest of which the whistleblower has been personally aware. Let me go back to this definition. I told you, ladies and gentlemen, a whistleblower is an individual. Okay, what does it mean? It means that a whistleblower cannot be a company. I told you, a whistleblower cannot be an association. The CSE, the famous French Works Council, cannot be a whistleblower. We will see that in the EU directive, because now we do have an EU directive dealing with whistleblowing, the EU directive does not share the point of view of France and considers that a whistleblower can also be an entity. But in France, so far, a whistleblower is an individual. The whistleblower must act selflessly. It means that the whistleblower must act in a disinterested way. He has only in mind the general interest. This is a different view from the American approach. In the US, a whistleblower can be financially rewarded for the alert. In France, no. You are not supposed to reward, to pay a sum of money to a whistleblower because he reported something. And I think that it makes sense in my view. But what does it mean? Because you can go a little bit further. What happens with people whose job is to be a journalist, a judge, a labor inspection? These people, on a daily basis, report facts. And they can blow the whistle. In my view, journalists, judge, labor inspector, when they act in the context of their professions, cannot be whistleblowers for one reason, because they are paid for that. So you can see that, again, this is not the general interest which prevails in this case. But don't get me wrong, a journalist in his newspaper can blow the whistle like you and me. In this case, he will not do it because he is a journalist. He will do it because he will be an employee of the newspaper. The whistleblower must be good faith. Very important. What does it mean? He must have reasonable grounds to believe that the information that he reported is true at the time of reporting. It's not an issue if at the end of the day, the information that has been reported was wrong. He must have grounds to believe that this information was true. What does it mean? It means that the Sapin 2 Act will not protect malicious, frivolous, and abusive reports. Only good-faith people will be protected. A whistleblower must personally be aware of the reported facts. We will see later on that this is not exactly the view of the EU, the European directive. But in France so far, you must be personally informed. What does it mean again, ladies and gentlemen? It means that the information reported cannot be mere speculation, cannot be deduction. That's one point. You cannot be a whistleblower by proxy, meaning that you cannot be a whistleblower because you just repeat facts that has been reported by other people. So, as you can see, the Sapin 2 Act was, I would not necessarily say cautious, but decided to have a relatively narrow definition of what a whistleblower is, in order to avoid extending the protection of whistleblowers to people who would not deserve it. So this is the French view. As I said, the whistleblower must have in mind the general interest. The general interest, or if you prefer the public interest, is not defined in the Sapin 2 Act. So, we are used to say in France that public interest means overriding interest of the public in knowing the reported information. Just let me give you some information, some examples. Damage to public health or environment is public interest. Illegal use of public funds is public interest. Okay? So, public interest is relatively large. And in a way or another, you counterbalance a relatively narrow definition of what a whistleblower is with a relatively large scope of the information that can be disclosed. Be cautious. There are some exceptions. There is some information that are deemed to be strictly confidential by nature. We have 3 of them, and interestingly enough, the European directive has the same view as Sapin 2. One is about military secret. I think you will not be surprised to hear from me that you cannot be protected as a whistleblower if you reveal a sensitive military secret. Okay. Second one, you will not be protected if you reveal medical information. Medical information is strictly privileged and confidential. Again, I think that in Japan, you probably have the same view. And last but not least, the attorney-client privilege. As you know, as lawyers, we are very keen to protect the confidentiality of the relationship between lawyers and clients. You cannot blow the whistle validly in France if you reveal an information that is protected because it was an information between a client and his lawyer. These are the 3 domains where there is no protection for whistleblowing. And now let's go. Regarding the protection. Yes, a whistleblower who breaches a secret may benefit from criminal immunity. This is the rule. He will be protected. We also have a labor protection, a labor law protection. You cannot discriminate against a whistleblower because he was a whistleblower, because he blew the whistle. You cannot, for instance, dismiss an employee because he blew the whistle. It's important to say that because this is a very strong protection again for the, I would say, the whistleblower. Very, very important to have this in mind. It is so true. It is so true that any dismissal will be null and void. Null and void. So, there is a burden of proof adjustment. What does it mean? If I go to the very straight, I would say that the person who blew the whistle is presumed to have acted in good faith. You, as an employer, if you decide to dismiss an employee who blew the whistle, I told you, you cannot do it just because the individual blew the whistle. However, if you can prove that the dismissal is not based on the fact that the employee blew the whistle, but because of the misconduct of the employee, then you will be allowed to dismiss the employee. Let me give you another example for you to fully understand. You are not allowed to dismiss a pregnant woman just because she's pregnant. That would be strictly illegal. But if the pregnant woman committed a misconduct that is serious enough and which is completely disconnected from a pregnancy, you will be allowed to dismiss her. This is the same for the whistleblower. Make sure that if you want to dismiss a whistleblower, you do have some objective consideration for that. This is very important. Otherwise, you can be sued. You can be sued before the French courts. So it's very important to indeed have this in mind. And then if we can go to the other slide, please. I'd like to speak a little bit about the EU directive. I take the view, personally, that France influenced the European legislator because France, like the United Kingdom and like some other countries, have a whistleblowing legislation. And it is true that there are some common points between the Sapin II legislation and, I would say, the EU directive. But there are also some differences. Under the EU directive, I didn't give you the date, sorry for that. The date of the directive is the 7th of October 2019. There is no need for whistleblower under the EU directive to have personal knowledge of the reported facts. This is a difference with French law, for sure. What does it mean? It means that the whistleblower in the EU directive can declare facts observed by third parties. This is possible. Under the EU directive, the whistleblower does not need to be selflessness and a good faith person. Regarding selflessness, good for the French legislation, the EU directive said that it will leave it to the member states to reward whistleblowers or not. I told you, the Sapin II Act ruled out this possibility. And I would be very surprised that the French lawmaker changed his view just because the EU directives give now to the member states the possibility to reward whistleblowers. I don't think it matches with the French culture. And of course, at this point in time, with the French legal context. Okay? Another point, the protection in the EU directive is extended to colleagues, to relatives of the whistleblower. In France, so far, only whistleblowers are protected. In the EU directive, any person who is a relative, who is a friend, who is a colleague, who would have suffered retaliation in a work-related context because their friend, their parent blew the whistle, would be protected as well. Obviously, this is not the French point of view. I may understand this extension. I believe, maybe wrongly, but I believe that you can have an issue in terms of proof. Let's assume, ladies and gentlemen, for a second, that a man and his wife work in the same entity. It may happen from time to time. Let's assume that the husband blew the whistle, and then wife says, I suffer retaliation because my husband blew the whistle. It may be very difficult to establish the existence of this causal link between the man blowing the whistle and the woman saying that she suffered retaliation. And then it could be definitely an issue. So this is something I have in mind, and I think that presumably Michel as well. Legal entities may report maybe whistleblowers. I told you, ladies and gentlemen, this is not the view of French law. So we will definitely have, well, to change, I think, the law. Michel, I think you will agree with me, because the EU directive, nevertheless, whether we like it or not, but this is the directive, give some clear guidelines about this. So our legislation will have to slightly be amended, for sure, because it's no longer completely consistent with the EU directive. One thing which will not change, and that's really good, is the reporting procedure. Under French law and under the EU directive, the whistleblower must report the facts internally in the company. This is true in the Sapin II Act. This is true in the EU directive. So you can report to your line manager, but you can also report internally to a person or to a body that has been appointed for this purpose, which makes sense, especially if your line manager is involved in the facts that you want to report. So in this case, you will report to what we call a referent. It can be another employee, it can be somebody who is at the board of directors, it can even be an external person, somebody who is not part of the company. Provided, obviously, that this person has the authority, has the decision-making authorities and prerogatives to take actions as means to react. If this person meets these criteria, it can be. You can also report to outside the company. Obviously, ladies and gentlemen, I told you, regarding the reporting line, it is important that you clearly state the terms and conditions of reporting. It is important, and you will do it in your whistleblowing policy. But under French law, like under the EU law, you can use external reporting channels if the company failed to take the necessary steps within a reasonable time frame. So you will want to avoid that the whistleblower report externally, because you want to have a chance to deal with the alerts in your company. First of all, because you are probably, as an employer, the person who has the possibility to do it in a more efficient manner than anyone else. But also because you do not necessarily want that facts reported go outside the company in terms of reputation, in terms of confidentiality of the information. You don't want this. So make sure that any complaint that is reported to your authorities receive an appropriate response in a timely manner. And it's up to you to decide which the deadline, i.e., as soon as we receive an alert, we acknowledge receipt of the alert, let's say in 1 or 2 days. Thank you for your alert, we have received it. We will deal with it as soon as possible. And then, in my experience, you should do it in a 2-month period. You should investigate if you believe investigation must be conducted, and do it in 2 months. Don't take 6 months to do this, it's too late. And the whistleblower will lose patience. and will blow the whistle externally, which is something you don't want necessarily. Let me nevertheless speak about external reporting channel. Under French law, like under EU directive, you can, as a whistleblower, go to the judicial authorities, the public prosecutor in France, to the administrative authorities in France. You can go to associations with at least 5 years in existence. So you can do it. Generally speaking, people will go to see the judicial authorities, the public prosecutor. Okay? And this is the right. You could tell me that what happens if the whistleblower did not comply with our policy, because according to our policy, the whistleblower was supposed to report to the company internally, and instead of doing this, the whistleblower blew the whistle with the public prosecutor. Well, first of all, this is his right. However, if it turns out that the facts reported were not true and even created damage to the company, you as an employer could decide to take disciplinary actions. In this case, ladies and gentlemen, the whistleblower who does not respect the internal reporting takes the risk of losing his protection as a protected employee, because I told you he is supposedly protected against dismissal in particular. What happens if within the next 4 months the judicial authorities do not react? It may happen. Then in this case, there is a third step. The whistleblower can report directly to the media, to the social network. He can do it. Actually, at the end of the day, if you are informed about an imminent danger, let's say for public health, you may wish to report directly to the media. Can you do it? Yes, you can. This is your freedom of expression. You can do it. However, as I said, you take the risk of losing your protection if the information that has been reported is wrong, inaccurate, create damage to the company. And you know, this is in line with the Council of Europe's recommendation issued in the 30th of April 2014, which said the following: the fact that the whistleblower has disclosed information to the public without having used the internal reporting system set up by the employer may be taken into account when deciding the level of protection to be granted to the whistleblower. So the whistleblower takes a risk. Now it's up to you to prepare a good, valid whistleblowing policy which will encourage people to report directly. And obviously, and this will be my final words, obviously people can report anonymously. Facts, it is possible under French law. But obviously, you will do your best efforts to encourage people not to use anonymity, because if people remain anonymous, how can you investigate on the facts that have been reported? So it will be up to you to remind whistleblowers that they are fully protected in the company, and you will make sure that they will not suffer any retaliation. Obviously, here at Franklin, with Hélène, with Michel, we are at your disposal to assist you. I will be very happy to answer questions. I hope I have not been too long, but of course there are so many things to say about this very exciting legislation, SAPA 2 Act, and the next steps, the changes. Thanks again for your attention, ladies and gentlemen. Hélène,
so,
maybe.
Yeah. So now we will discuss on difficulties or concerns of Sapin 2 for foreign companies. So the first issues for employers are to deal with Sapin 2 Act and other French rules. As I told you previously, you won't find quite a lot of things regarding processing employees' data on the GDPR. So you have to have a look to the French Data Protection Act. But if you have a look to the French Data Protection Act, you will see that the French Data Protection Act tells you to look at the GDPR. So this means that or you have specific provision in the French Labor Code regarding employees' personal data, processing employees' personal data, or you have to have a look to the French Data Protection Act, and if you don't find anything, you have to look at the GDPR. So far, we do not find any provision contrary regarding the whistleblowing scheme within the French Labor Code and within the French Data Protection Law. So far, the case laws are quite harmonized. The French Data Protection Authority case laws is quite in line with the French Labor Code. So far, we won't find anything very contrary to between French Labor Code and French Data Protection Act, but sometimes in French data protection rules, you can find more precise rules than in the French Labor Code. You have to look as well as an employer, as a company, to Sapin 2 Act and similar obligation in other countries. As Patrick said previously, we can find some differences between countries and countries. So this means that if you want to implement global policy, I mean a policy that employees can apply worldwide, you have to draft as well local, national policies in order to take national laws into account. What you have to do as well as an employer, and what is not very easy to set up, is implementing. Michel, I wrote Sapin 2 Compliance Network. I would say anti-corruption compliance network within the group. So, and it is very interesting for people within this network to discuss together, explaining that in France we can do that, but in the UK we can't, etc., etc., in order to work better together. And of course, the main issue is employees training. I mean, explaining employees that can become whistleblower how to use the whistleblowing scheme, as Patrick told you previously. And of course, training employees that will deal with the reports. So other issues which are GDPR issues for employers is that in the data protection rules, I mean both French and GDPR, we have something which is very difficult to deal with. It's the data minimization principle. This data minimization principle is in the GDPR, and Patrick, it is as well in the French Labor Code. As in the French Labor Code, you are not allowed to gather and process employees' data which is not linked to the mission within the company. So, for instance, this means that you are not allowed to collect and process data regarding the father, mother, etc. of the employees. But of course, in the scope of a report, maybe this can be the main issue of the report. So this means that if we take the example regarding corruption, you receive a report saying that one of your employees' father works within the company of your main contractor. And because of this link, your employee decided to work with the company of his father's. In this case, so we have to assess this case by case. I mean, of course, generally you would have to gather information regarding the family of your employees. Sometimes it can be discrimination. But in this case, if you receive a report saying, oh, we change our main contractors and our employee decided to contract with the company of his father, it could be corruption. And in this case, it won't be forbidden to collect such data. But of course, this minimization principle is very difficult to deal with, and it's a very case-by-case assessment. Second is the information of data subject. So as I told you, the GDPR says employees' data, please refer to your national law, but regarding information of data subject, the French Data Protection Act will tell you, please see the GDPR. So regarding information of data subjects, you have to comply with GDPR, which is a quite burdensome obligation. And in the labor code, we have also an article regarding employees' information, but this article is very generic. So if you comply with the GDPR obligation per se, you will comply with the French labor code. One thing is very important is the retention period. So, and this is very difficult to handle with. You must not retain data longer than necessary. So we will see the CNIL's guidelines in a couple of minutes, but you have to take care, because in France we have guidelines regarding whistleblowing scheme only, but dealing with whistleblowing reports, it's more than dealing with a whistleblowing scheme. So this means that if you receive a report, the report will be processed within your whistleblowing scheme, but you will download the data, discuss the data between different employees within the group, maybe within different company within the group, and then you will have to take care of the retention period of this data, which is not anymore stored in your whistleblowing scheme. And of course, the last GDPR issue is transfer and disclosure of collected data. So, as we told you previously, the French Data Protection Act, the Supervisory Authority, sorry, the CNIL, issued some guidelines regarding whistleblowing scheme. So if we look at the next slides, you will see that these guidelines is not intended to be real soft law. The CNIL said in this guideline that this guideline will help companies to be GDPR compliant. So this is guidance is more than soft law. So this means that sometimes if you read these guidelines, you won't find very detailed information. It's not a toolkit. It's just something to help you. But the CNIL won't do the assessment for you. So this is your duty to do the GDPR assessment of your whistleblowing scheme. So the CNIL says that you have to be in compliance with GDPR and any other applicable law. You have to draft a data protection impact assessment. We will discuss that later on. And you have to identify the gap between that the CNIL said in the guidelines and your whistleblowing scheme and your reporting policies more globally. So if we look at the scope of the guideline issued by the CNIL, as I told you previously, the guidelines are restricted to the whistleblowing scheme and not to the reporting scheme and reporting processes entirely. And this is because European data protection rules are very linked to processing of personal data. We mean tools, so IT tools. So if you want to be GDPR compliant, you have to assess your whistleblowing schemes thanks to these guidelines, but all the other part of your processing, maybe internally, all the reports processing, the reports disclosure, transfer of information, you have to do it on your own because so far there is no guidelines issued by the CNIL or any other European data protection authority. So as Patrick told you previously, national defense secrecy, medical secrecy, and attorney professional secrecy are out of the scope. So this means that if you receive, if the whistleblowing scheme receive a report regarding, for instance, medical secrecy or secrecy, attorney professional secrecy, this means that you have to say, please do not use this whistleblowing scheme to do this report. Whistleblowing scheme as well have to collect and process data, and those data collected thanks to whistleblowing scheme cannot be reused internally and especially against the whistleblower. So this is something very important in the GDPR. It's the principle of limitation of purposes. If you collect and process data for some purposes, you cannot reuse the data for other purposes. So this is very important because this is something that we can find very frequently in companies. So, and this is why the GDPR does not allow you to retain data for a very long period of time, to impeach and to help you not to reuse this database. Because of course, if your data is in your IT system, it's very easy to reuse the data, but it's not possible. And in this case, it could be a breach of the Data Protection Act, but also of the labor code. If you dismiss, for instance, an employee thanks to the reusage of such data. So in such a case, it's very easy to prove, because if you collect the data for a very long period of time and reuse the data afterwards, it's very easy to prove, and the sanction of the data protection authority can be very high. So if we look at the scope of the guideline issued by the CNIL, we will see that we have different scopes possible. So as you know, and as we told you previously, not 100% of the companies have to comply with SAPAN 2 Act. So this means that, of course, you can implement a whistleblowing scheme if you have to comply with SAPAN 2 Act. But sometimes you are not in the scope of SAPAN 2 Act. So there is another example, and Patrick told you some words previously regarding the very beginning of the whistleblowing scheme and the CNIL discussions. So this is the scope of the very first guidelines issued by the CNIL. It is fight against bribery and trading influence. The third case where you can use a whistleblowing scheme is duty of vigilance, stated by the French Code of Commerce. So it can be serious threats on fundamental liberties, health and safety, environments, etc. You can have also a whistleblowing scheme on a voluntary basis if you are not on the SAPAN 2 scopes. And in this case, you have to draft specific guidelines and explaining which kind of breach you will whistleblowing could report. And you have some half and half whistleblowing schemes, which is a combination of SAPAN 2 Act and a voluntary basis. So at the very beginning of your assessment, you have to determine what kind of employer and whistleblowing scheme you have to implement. So first case, SAPAN law, second case, voluntary basis, and third case, an half and half. This is very important because sometimes you will, if you are in the first case, SAPAN 2 Act, you will have to entirely comply with the SAPAN 2 process scheme. In other ways, sometimes it can be, as it is a voluntary basis, you are free to draft your own policies. Another thing which is very important under GDPR is the legal basis of your data processing. This means, of course, if you implement the whistleblowing scheme in order to comply with SAPAN 2, your legal basis is compliance with a legal obligation. In this case, it's very easy. If you are in the other case, for instance, if it's a 100% voluntary basis whistleblowing scheme, in the GDPR, you have an article 6.1F, which is the legitimate interest of the company. In this case, if you are not in the scope of SAPAN 2 Act, and if you implement whistleblowing scheme on a voluntary basis, and the legal basis is legitimate interest, you will find some differences in processing of personal data of employees or reporters or witnesses, etc. And if you implement SAPAN 2 Act whistleblowing schemes, the right of the data subject will be less important than if you implement a scheme on outside of the scope of the SAPAN 2. Something which is very difficult and burdensome to conduct an assessment is if you are in a hybrid scheme. This means both SAPAN 2 and voluntary. In this case, you have to do the assessment twice. So this is quite burdensome because doing an assessment itself is not very easy to conduct. So the guidelines of the CNIL contains several articles and has plenty of guidelines issued by the CNIL. The articles are always the same. So, I mean, Article 1, data subject, Article 2, purposes, Article 3, disclosure, Article 4, retention period. So, the CNIL issued a couple of months ago guidelines regarding processing of employees' data within a company for HR purposes, and you will find the same Article 1 data subject, Article 2 purposes, etc. So regarding the employees of the whistleblower or reporter, as Patrick told you already, depending on the case, you can have, I mean, if this is a voluntary whistleblowing scheme, for instance, you can recommend or compel reporters to provide his or her identity. If the reporter has given his or her identity, you will have to keep this identity confidential. And this means that you can or not implement sophisticated tools to pseudonymize data, because it's very difficult to process data if data are 100% anonymous. But you can implement very sophisticated or very easy to implement tools to pseudonymize the data within your personal data processing. If the applicable rules do not compel a reporter to identify him or herself, as a company, you cannot encourage a reporter to report anonymously, the CNIL said. And this was the CNIL said during in the first guidelines in 2007. Sorry, and we had the same provision in other EU countries, such as Portugal, for instance. If the reporter wishes to remain anonymous, you must, so the CNIL said that you must establish, the reporter must establish the fact in a way that you can investigate. So this means that if the reporter called the whistleblowing line explaining, I want to remain anonymous, and I know that at the financial departments something very bad happens, this will not allow you to conduct a proper investigation. So if the people want to remain anonymous and do not provide you with sufficient detail on the report, it will be difficult for you to investigate. And this is confirmed by the CNIL. So this means that you have a decision from the Data Protection Authority helping you if you want to explain the reporter that his report will not be investigated if he does not provide you with sufficient details. And an investigation on the fact must be conducted with a specific process And this is, sorry, this is the purpose of your internal policy on whistleblowing. So it's quite easy to draft whistleblowing policy because for French companies, the CNIL guidelines help you to draft the policy. This means that they give you the main purposes, and you just have to draft something in between the guidelines of the CNIL. Some categories of personal data process. So, you know, the CNIL divided this part during the report and during the investigation. So this means that, and as well, the CNIL divided voluntary basis whistleblowing scheme and subject act whistleblowing scheme. So this is very important to underline that during the report you will gather information regarding the reporter, the whistleblower, regarding some witnesses, for instance, and regarding people which are not within your companies, for instance, your contractors, your clients, etc. So this means that whistleblowing schemes does not allow you to collect employees' data, but also contractors' data, suppliers, agents, clients, witness, which can be, for instance, family of one of these persons. So this means that you will not process data regarding your employees only. So this is very important because you have to gather quite a lot of information regarding the report, what happened, how it happens, how do you know that, etc. And the thing is that you will have to collect what the reporter says, and sometimes the reporters will tell you something that you can't process in a personal data processing in France. For instance, you have to take care if the reporter tells you something regarding sensitive information. For instance, collecting criminal data is forbidden in France. So if the reporter says, I know that this guy do something wrong within the company, but I know that he has been dismissed because he has been found corrupted in this previous company. This can be an offense, and you have to take care if you record such kind of processing of information in your processing of personal data. This is the same with information regarding privacy, regarding sexual preferences. So you have to take care when you record the information given by the whistleblower during the report. Afterwards, information which allow you to exercise or defense of a legal claim would be allowed. So this means that if the reporter says that he is aware of a breach of a law, and if you remain on this report only, if you don't collect data regarding what some people could have done previously in other companies, etc., it's allowed to collect data regarding offenses which are linked to the report, but only which are linked to the report. Regarding the offenses that you can process, it's written, it's in SAPAN 2, sorry. So as long as the offenses are in the scope of SAPAN 2, it's allowed. And the CNIL says also that you can collect some data more generally regarding offenses, but you have to take care on what you are collecting in this case. And then, of course, once you receive the report, it is possible for the company, what we call the company implementing a data processing under GDPR is called the data controller. So you, as an employer implementing a whistleblowing scheme, are regarding as a data controller under the GDPR. This is the same in every EU country. So this means that if you hire some contractor to deal with the report, the contractor will be most of the time data processor. This means that they collect data on your behalf and under your instructions. So if we look at what the CNIL says regarding recipients and authorized persons on personal data collected, this is very important because so far in the previous guidelines, it was very difficult to assess whether within a group it was possible to disclose data regarding a report. So this last version of the guideline published 6 months ago is quite clear regarding the data disclosure within a group. So personal data can be accessible or disclosed to authorized persons regarding of their function or role within the company. What are authorized persons within your organization? It's up to you to decide within your whistleblowing report policy. So this means that you can decide that the authorized person will be the compliance department, the internal audit department, etc. So of course, those authorized persons can't be something like 80% of your employees. This authorized person has to be dedicated person or dealing with compliance and trained person, so who knows how to deal with a report and a complaint. So all the access authorization must be documented and monitored. This means that you have to have a list of these authorized persons, and you can track the logs on your IT systems gathering and processing data regarding the reports in order to check whether or not authorized person or non-authorized person has an access to this data. Of course, since the GDPR, data processors are regarding as recipients. And since the GDPR, you have an obligation to draft a contract with your processing, and Article 28 of the GDPR provides you with the list of the information that you have to insert in your contract. Please note that some data protection authorities has issued compulsory template already. This is the case in the Netherlands. In France, the CNIL will issue a template, a binding template very soon. So authorized person can act on behalf of the controller. So this means that within a group, you can share data regarding reports with your colleagues in other countries, for instance, or in other companies of the group, and with the vendor in charge of handling the reports. So afterwards, we will find the list of these recipients. And something I want to point out is that in Europe yesterday, we had a very huge caseload regarding European Court regarding the international transfers of data. Just to tell you a couple of words on this, international transfers of data outside of the EU is forbidden, except if you can find a legal basis to transfer your data. Good for you, because Japan has been considered by the EU Commission as providing an adequate level of protection for personal data. So transfers of data from Europe to Japan is free. But the court said yesterday that transfers of data between Europe and the US can be highly restricted. So this is a very, very important decision. And take care, because if within your company you want to share data with people established in a non-EU country, which is not regarding as having an adequate level of protection for personal data, this can be a huge issue. So we are waiting for decision of the EU Commission and other data protection authorities in order to assess whether it is still possible to transfer data to some countries. So Japan of course is okay because it's regarding us fine, but in other countries things may change in the very short future. So if we look at the retention period of personal data, the thing is that GDPR applies only to personal data. So if your data are anonymized, the GDPR won't apply. So you can store and process anonymous data as long as you want, because they are anonymous. But if you want to be sure that they are anonymous, you have to check whether your anonymization process comply with the anonymization technique adopted by the European Data Protection Board, which is an entity within the European institution. So regarding the retention period of non-anonymized data, so you can decide to anonymize the data after the report investigation or delete the data. So 2 months after the end of the investigation process, and if disciplinary action are conducted, you can store data and process data during the applicable statute of limitation. So this means that, for instance, criminal statute of limitation in France could be 6 years, so it can be 6 years. So it could be longer if you have court decision and appeal, etc. So if sometimes it could be more than 10 years, for instance. And regarding closed cases, you can archive the closed cases or anonymize the closed cases. The last slide is focused on security measures. The CNIL in the guidelines provide you with a huge list of security measures that you have to implement within your whistleblowing scheme. It's too long to put all the security measures within a slide, but it's very long and very burdensome. If you do not comply with the security measures, it can be an issue. And if you look at the slide 32, you will see that you have specific obligation to inform data subjects. This is an issue as well, because of course you can, within your internal policy, you can insert an information notice for your employees. But if your report, the report focuses on other people than people within your company, it could be an issue to assess how to inform them. Of course, as long as you investigate on the report, you have the right not to inform them. But afterwards, after a certain period of time, you have to inform those people which are not your employees, sometimes which are not your vendors. So this can be an issue to address the information obligation. Sometimes you can post something on your website in order to inform, but maybe the CNIL in France won't consider this as sufficient. And of course, you have all the rights, the data subjects' rights, as you can find in the GDPR. So the right to object, of course, if your investigation proves that there is a breach of the law, the right of objection won't work. But sometimes this right can work, especially if you do not comply with the retention period stated by the CNIL guidance. So I can see that you have some questions. Do not hesitate to ask you some questions.
Okay, I think that we had several questions from the webinar person. So if you can any answer of one of them. Hello, Patrick.
Yes.
Yeah, can you get any question? I sent in earlier.
Well, I don't know if people have any questions. No, maybe actually, I have a question to Hélène.
Okay.
If you don't mind, I think an important question is, you have made an investigation.
Yep.
Further to a whistleblowing alert. And then, for some reasons, the person who has been the subject of the whistleblowing has been dismissed. Okay?
Okay.
And this person goes to court. The question is, how long are you supposed to keep the information? Because at the end of the day, you don't know if a person will go in court. So should you keep it forever, or is there a specific limit of time, Hélène?
The thing is that, good question, Patrick, actually. The thing is that in order to comply with the GDPR and data protection rules more generally, you have to divide your assessment and all your policies into what is within the whistleblowing scheme and what is, and this is the purpose of the guidelines, and what is outside your whistleblowing scheme. I mean, within your HR department files, and as long as it is within your data HR IT system or HR disciplinary files, etc., you can store data as long as the statute of limitation allows you. And as you know, it could be very long. So the more important is that to comply with CNIL's guidelines retention period within your whistleblowing scheme. But as long as the data has been downloaded or transferred within your HR IT system, this is the HR rules which apply. I think that you had some question regarding the data protection impact assessment. The data protection impact assessment is a very burdensome task. For instance, the Dutch Ministry of Justice published its data protection impact assessment for Microsoft 365. It's something like 200 pages. It is something burdensome to do. If you are a controller, you have to ask your data processor to help you, because sometimes you won't have the information to fill the data protection impact assessment. I have to tell you that last week we discussed with Michel Sapin, because one of my clients, which is investigating by the French Anti-Corruption Agency, and the French Anti-Corruption Agency asked whether the company complied and draft the data privacy impact assessment. So it is very important to be able to disclose this DPIA to any kind of French administrative body. And this is very burdensome. And to me, within a global group, it is very difficult to do a DPIA, so data privacy impact assessment, for all European countries. You have to tailor for each member state, which is very burdensome, but you can't do otherwise. And the thing is that in France and in several EU countries, you have to draft it in local language. So this means that in France, it has been to be drafted in France. And don't forget that in the process of your DPIA, you have to ask the advice of the representative of the data subject. That means that of your workers' representatives. So this is a huge thing, DPIAs.
Okay, thank you very much. Too much details about this question and answers. Thank you very much, Ellen, and also the Patrick, and also the Michelle.
So, thank you.
Thank you very much.
Thank you very much to you guys.
Thank you very much.
Now we so finish this seminars. We will switch over to the person in the Japanese.
DQuest ヘルプライン事業部の福山と申します。本日は DQuest シンポジウムをご視聴いただき誠にありがとうございました。今回フランス法をメインに開催させていただきました。今回の企画といたしましては、弊社のセミナーなどでアンケートを取らせていただいた結果から、まずはフランスを皮切りにという形で開催させていただきましたが、今後はこのような形のシンポジウムを適宜各国バージョンでお届けできればと思っております。弊社はグローバル内部通報を承ることを強みとさせていただいておりますが、内部通報にかかるご相談のみならずですね、各国の法律事務所をご紹介することも可能でございますので、当該国や地域で何らかの法律相談などがございましたらお声掛けいただければと存じます。最後に弊社のグローバルネットワークをご紹介させていただきます。ご覧いただいているスライドは弊社の現状の提携先の法律事務所の一覧になります。弊社がですね、海外の内部通報を承る際には、その対象国が、や地域がですね、初めての場合には、まずはそこを業務範囲としている、提携先の法律事務所を探すことから、始めております。その際のネットワーク構築については、世界各国に会員を要しているACFE という米国に、アメリカに本拠を持つ不正検査士協会のネットワークを活用しております。弊社グループ内で、日本での ACFE 事務局を務めていることからですね、そのようなネットワークを活用することができるということになっております。で実際このような形で世界で、内部通報を承る展開をさせていただいておるんですけれども、今現時点でですね62カ国の内部通報を承っております。このような背景がございますので、今後もですね内部通報のみならずグローバルコンプライアンスで弊社および弊社ネットワークをご活用いただければ幸いでございます。 最後に、本シンポジウムの後にですね、画面が切り替わりまして、アンケート画面に遷移、させていただきますので、それにぜひご協力いただければと思います。お答えいただくのに2、3分もかからないかと思いますので、どうぞよろしくお願いいたします。また、今回のですね、内容については、日本語字幕付きのものを8月中旬をめどに YouTube で配信する予定でおります。改めてYouTube のURL ですとか、そういったものをご案内させていただきますので、どうぞ記者内でご考覧いただければと思います。それでは本日のシンポジウムはこれにて終了となります。長い時間のですね、ご視聴誠にありがとうございました。今後ともどうぞよろしくお願いいたします。